Hey guys, what's happening? This is a quick video to talk about Corona COVID-19, that small matter that's affecting the entire world at the moment. Obviously, it's touching every aspect of our lives, and the law, and in particular contract law, is no different. It's having an impact on that as well. What I want to share today is a suggestion and a recommendation that it should now be best practice that if you are about to enter into any contract, that you should have a corona clause in the contract, or at least have given corona due consideration and decided that you don't need to mention it in the contract. Although I would be amazed if you don't need to mention it. You should be talking about it. You should be dealing with it in the contract up front. It's always generally better in a contract to deal with an issue up front rather than sweep it under the carpet and try and deal with it later down the line. So what I want to do today in this video is give you 6 points to think about for a corona clause. And the idea of this is that when you are in early discussions or in discussions around a contract, these 6 points will give you some guidelines of things to think about, which will help marshal the conversation, discussion, and the risk allocation between you and the other party in the contract. So, right, I'm going to dive straight in with those 6 things. Okay, so point 1 to consider is relief from obligations under the contract. And essentially what this means is that if a party is affected by corona, then is it fair and reasonable that they get relief from their obligations under the contract? So for example, if a party has to deliver something by a particular date, and they've agreed to that date under the contract, but then they're unable to fulfill that contractual deadline because of corona, then should they get relief? Is it right that they get relief, or could it be actually that you don't want them to have relief, but actually they need to price it accordingly? So should they put in a time and price buffer that effectively means they take the risk of that? Now, the other party may not want to do that for a very good reason, but these are the kind of considerations to have when you're thinking about relief from an obligation. Okay, so point 2 to think about is really whether there should be an extension of time. So just related to point 1, we were talking about relief from obligations, then point 2 is really how much of an extension of time should a party be given to fulfill the obligation? Should it be an indefinite amount of time until the corona event that's affecting them clears and passes? Should it be a few weeks? It's worth discussing these issues. Now, potentially, what should maybe happen is that the party that's affected gets an extension of time until they are clear of the corona event, or it's no longer affecting them. But obviously, how long can that go on for? So there must be some sort of long stop date, some sort of overall deadline, and that might be something like 3 months, 6 months, a year. Okay, so point 3 to consider is whether there should be a complete or partial suspension of the contract. So i.e. the contract sort of goes into sort of hibernation or cryo freeze, a bit like how the rest of the country is and the rest of the world is at the moment. We are sort of in this state of sort of sleep or slow motion where everything is still ticking along but sort of at a slower pace. Points 1 and 2, we spoke about relief from obligations and the extension of time. Those 2 points suggest that the contract will carry on in some form, whereas this point about suspension really is almost that the contract is going into a period of hibernation until this all passes over. And again, if it does go into this state of suspension, suspended animation, however you want to describe it, then at what point do the parties go, enough's enough, we can't just have this contract sitting in limbo here, we need to terminate? So again, there probably needs to be some sort of long stop date to deal with any kind of deep suspension or deep freeze of the contract. So in point 2, I mentioned about an extension of time to fulfill obligations under the contract that have been affected by corona. Now in this point 4, we need to give consideration to whether there should be an impact on the price of the contract and the prices. So if you have agreed one price under the contract, and then the supplier is affected by corona, should they be entitled to increase their prices? They would probably argue, and they would probably want an ability to increase their price, because the chances are that if they are affected by corona, then it's going to have an impact on their supply chain, and it may cost them more to fulfill their obligations. So they may argue that they want to have an ability to claim for additional monies due to being affected by corona. Now, on the flip side, if you are the person who's receiving the goods or the service, you may well say, well, hang on, we agreed a fixed price, that price needs to stay in place. So there's a trade-off there, and there's a negotiation to be had. Okay, so point 5 is consideration should be given to the right to cancel or terminate the contract. So if a corona event or corona affects the parties under the contract, should that create an automatic right to terminate? Should it mean that if the corona event is still affecting the parties and the ability to perform the contract after, say, a month, 3 months, 6 months, should it mean that there is an ability or right for the parties to then recognise that the contract is becoming untenable and therefore it should be terminated? And if there is termination due to a corona event, coronavirus, then what are the implications of that in terms of the sort of the price, who should be paid what in the event of termination? Should there be refunds? All of these things need to be given consideration. And point 6 touches upon point 5. Point 5 was to do with the termination of the contract. Point 6 really is to do with payment and refunds under the contract if it is in fact terminated. So if, for example, you have paid for something in advance and that thing that you've paid for you're not going to receive now because the contract's been terminated, should you get a full refund? Should you get a partial refund? Or should you get no refund at all? So there you go, a very quick overview on what you should be thinking about in relation to your contracts and corona. Just to recap on that, you should definitely be considering putting a corona clause into all of your contracts going forward. I personally think that if you don't expressly deal with corona, then you're making a big mistake, because it is so prevalent at the moment and it will have an impact on so many different things that you should expressly deal with that up front. And then in terms of what that corona clause should look like, obviously the detail of that will need to be addressed by your lawyers, but in terms of giving your lawyers a sort of a framework or some guidance in terms of the things that matter to you and the other people in the contract at a heads of terms level, i.e. a commercial level, when you're discussing the key points of the contract, you may wish to think about the following 6 key issues to do with the contract, which is, is there going to be relief from corona? Should there be extensions of time? Should there be a suspension of the contract? Should there be an entitlement to increase prices? Is it reasonable that a party who is affected by corona can increase their price because of the additional disruption and the additional cost associated with that disruption? You need to be also thinking about corona in relation to rights of termination and cancellation, which is point 5, and then linked to point 5 is point 6, which is what compensation the parties get in the event of termination. So there you go, guys. I hope this video has been useful and helpful. Whether it has or it hasn't, leave comments below. If you've been affected, if your contract's been affected by the coronavirus, I'd love to hear about that. So put your comments below. It'd be interesting to hear your stories of how this is affecting you. My name is Mark Lynch. I am a property investor, property developer, property development lawyer. I have my own law firm called Law.X, which is dedicated to serving property developers. And remember, your contract should be your asset, but it can become your liability.